Thank you for joining us tonight. This is the first lecture in our fall NHA University series focused on women's history. With us tonight is Dr. Catherine Allgor, president of the Massachusetts Historical Society. Previously, she had been the Nadine and Robert Skotheim Director of Education at the Huntington Library in San Marino, California, and a former professor of history and UC Presidential Chair at the University of California, Riverside. Allgor attended Mount Holyoke College as a Frances Perkins Scholar and received her Ph.D. with distinction from Yale University, where she also won the Yale Teaching Award. Her dissertation received a prize as the best dissertation in American history at Yale and the Lerner-Scott Prize for the best dissertation in U.S. women's history. She began her teaching career at Simmons College and has been a fellow at the Radcliffe Institute for Advanced Study and a visiting professor of history at Harvard University. Allgor's first book, Parlor Politics, in which the ladies of Washington helped build a city and a government, won the James H. Broussard First Book Prize from the Society for Historians of the Early American Republic and the Northeast Popular Culture American Culture Association Annual Book Award. Her political biography, A Perfect Union, Dolly Madison and the Creation of the American Nation, was a finalist for the George Washington Book Prize. In 2012, she published Dolly Madison, The Problem of National Unity and the Queen of America, Mary Cutt's Life of Dolly Madison. President Obama appointed Allgor to a presidential commission, the James Madison Memorial Fellowship Foundation. Dr. Allgor also serves on the board of directors of the National Women's History Museum. Thank you so much, Catherine, for joining us tonight. I'll turn things over to you now.
Hello, everyone. Good evening. Amelia, how am I? You can hear me and see me? Good, thank you. It's such an honor to be here today. Thank you, Amelia, for inviting me, and thank you, Ashley and Al, who make all the magic of tech work. Before I begin, I just want to say that I want to give a content warning. I mentioned the word rape twice. So let us begin, and let's start with my title, The Word Every American Should Know. Sounds a little bit like I'm on a crusade, and I sort of am. So let me tell you how it started. In 2012, I was invited to a Gilder Lehrman Teacher Training Institute at Mount Vernon. And the topic of the institute was what was going to be the next area of research in studies on the Revolutionary era. So scholars who did particular subject areas were invited, and I was invited because I am a historian of women's lives and gender, and that's what I'm going to speak to. Coverture, and that's the word I want every American to know, was part of my presentation. My audience was about a dozen very eminent historians and about 60 of the very best history teachers in the country. And as I talked about coverture and its role or non-role in the American Revolution, I was dismayed that none of the teachers had ever heard the word. Now, the eminent historians had, but they just didn't think it was very important. And that took me down a research path. And ironically, I realized in sort of doing a deep dive into coverture that I hadn't fully understood the implications of that topic, even though I was well into my teaching career. So today I'd like to share with you what I found as I took this journey into history, and I promise you it will be a story with a twist. So let's start with a definition. At the time of the American Revolution, American women, along with their English counterparts, were legally bound under the institution of coverture. Coverture held that no female person had a legal identity. At birth, a female baby was covered by her father's identity, and then when she was married, by her husband's. Husband and wife became one, and that one was the husband. As a symbol of this subsuming of identity, women took the last names of their husbands. Because they could not exist legally, married women could not make contracts or be sued, so they could not own or work it. Married women owned nothing, not even the clothes on their backs. They had no rights to their children, so that if a wife divorced or left a husband, or vice versa, he leaves her, she would not see her children again. Married women had no rights to their bodies. That meant a husband could have a claim to any wages generated by his wife's labor and to the fruits of her body, that is, her children, he also had absolute right to sexual access. Within marriage, a woman's consent was implied, so under the law, all sex-related activity, including rape, was legitimate. His total mastery of this fellow human being stopped short, but just short, of death. Of course, a man was not allowed to beat his wife to death, but he could beat her. Now that's the law. The law doesn't always reflect real life, and in truth, equity practices ensured that coverture on the ground was not as restricted as the black letter law indicated. Though a woman could own nothing, men who wanted to pass their wealth through their daughters to their grandchildren devised legal ways to keep money and property out of the hands of sons-in-laws. And the demands of everyday life and of commerce played their own parts. Though a woman could not make a contract, plenty of women did business and trade, either on their own in a legal exception called femme sole, or for absent husbands. Wives often ran businesses alongside their mates, with the local community acting as monitors and enforcers. So even though the law said one thing, in practice, there's a lot more latitude. And we must assume that though husbands had the right to marital relations at will, there was probably a great deal of negotiation around sex. Now, coverture was what Abigail Adams was talking about in her famous Remember the Lady's Letter to John. She referenced the long-standing nature of coverture when she bade him to be, quote, more generous and favorable to them, the present-day ladies, than your ancestors. Abigail Adams understood the corruption of absolute power as clearly as any revolutionary theorist. She said, do not put such unlimited power into the hands of the husbands. Remember, all men would be tyrants if they could. Abigail even obliquely referred to the shame of marital rape and physical abuse when she proposed, why then not put it out of the power of the vicious and the lawless to use us with cruelty and indignity with impunity? Men of sense in all ages abhor those customs which treat us only as the vassals of your sex. And the reason we know she's talking about physical abuse or sexual abuse is the 18th century meanings of words like vicious and vassals, and they refer to depravity. The reason I made this my quest, my crusade for every American to know the word coverture and what it means, is I think that we, and by that I mean scholars, teachers, educated Americans alike, have not really come to terms with the idea that our founding happened with coverture in place. Coverture is the ghost in our machine. And I'm referring, of course, to the noiseless machine James Madison intended the Constitution, and indeed the whole structure of the federal government, to be. But just as there always seem to be gremlins in our most expensive cars and computers, our machine of government is haunted by the exclusion of women. And I say that anyone who is interested in studying about the American Revolution has to learn certain terms like republicanism and liberty and what they meant to the people of the time. And my argument simply is coverture should be part of that historical lexicon as well. The Revolution did not change coverture at all, nor did the Constitution, though new rights for men meant some new rights for women. Just by extension, thanks to the Bill of Rights, women partook in many of the rights that men enjoy. Law protected the property of widows and single women. With their husband's permission, married women could assemble freely, practice their religion, and exercise free speech. They also had the right to petition and to trial by jury, although the jury of their peers would be made up of men. Now, it's important to understand that enslaved people enjoyed none of these secondhand rights. So wives did have legal rights in extremis. So in an extreme case, a wife could divorce her husband or swear out a warrant against him if he committed a crime against her. And of course, slaves could not divorce their masters. And the law provided no refuge against excessive physical force for slaves. But when it came to the rights as specifically women, wives, legally the only difference between an enslaved person and a married woman was that a husband could not sell his wife, prostitute her out. But even these distinctions were shaky. Some of the first persons sold in North America were white women from England sold to Virginia colonists as wives. The comparison between the legal status of enslaved people and white wives is less a face-to-face contrast and more of a side-by-side assessment. The status of both groups overlapped. There was no legal treatment for enslaved people that at some times and places did not apply to wives. Marriage under coverture was an oppressive system, and we have a hard time really comprehending the scope and depth of that. So one of the great discussions in American history generally is how colonial America instituted slavery so quickly and how it became so all-encompassing, again, fairly quickly. Meaning by the late 1600s, colonial America had one of the most total systems of slavery in the world. It was lifelong, immutable, and heritable. And I recently said that to someone and they said, can you say that? And it sounds so definite, but the truth is slavery as an institution has been around, and I use the present tense, since biblical times, we know that, but who a slave was and whether a slave could stay a slave or change into something else, really, and how long their terms of servitude differed all over the place. But again, the colonial laws quite quickly made the status of an enslaved person something that lasted their entire life and could not change unless they were freed by a master or bought by somebody and freed. And it was inheritable. That is, it didn't just last through your lifetime, you passed it on through your descendants. So how did this happen? There are a lot of great books about it. American Slavery, American Freedom is an Edmund Morgan book about it. And there's a lot of theories about why we ended up with this type of slavery. But the study of gendered systems like marriage can supply one important factor. So it's not a coincidence that the early slave codes began with restrictions about sex and marriage. But the slavery-marriage connection goes beyond that. In short, it was easy for colonial men to construct a system of almost total control over African and then Black bodies because they had a system in place already. It was marriage, and it proved a highly workable model for chattel slavery, even supplying slavery with a justification based in nature. So the marriage, ideas about marriage, legal and otherwise, used what they perceived to be the natural inferiority of women to rationalize the subordination of women, in the same way that the institution of slavery would go on to develop a race-based biology that concretized slavery. Indeed, it's interesting when you look at the 19th century, when after the American Revolution, there are enslaved Black people, but there's also free Blacks. But even freed Blacks living in the North didn't enjoy the same full citizenship, the range of citizenship that white men did. And when free Black men in the early 19th century would say, we're citizens, why don't we get to do this? Why don't we get to do that? Why don't we get to vote? The law pointed toward women and said, women are citizens and they don't vote and they don't enjoy full citizenry. And it was almost a justification for keeping Black men in this kind of subordinate position. Later, the 13th, 14th, and 15th Amendments would remedy that inequity, at least in theory. I say in theory for Black men, but women would remain behind only partial citizens. So I'd like to get back to the idea that women enjoyed ancillary rights under the new system. As I mentioned, they could assemble freely, petitions, but only in the case of married women if their husbands let them. Sometimes we use the phrase second-class citizenship, but really the contrast in liberties for men and for married women was so great, it was more a case of steerage citizenship, really the bottom of the boat. So this gets us to the question of, if we're at the revolutionary moment, and I've already spoiled it, I'm going to tell you that nothing happened to coverture during the revolution, but we can ask ourselves, what could the founding men have done about coverture? Is it fair to take them to task for not abolishing or at least amending the law in the way that Abigail Adams asked? Well, let's see what the founders had to say for themselves. And at first glance, they seem rather silent. If you do a word search for coverture in the newspapers, for instance, you're not going to get much of a return. And so we feminist historians in the past have let the founders off the hook around the issue of women's full citizenship. We used to say that they just didn't know any better. They couldn't imagine other options. That is, of course, what we used to say about the issues of the founders in slavery. But just as new research on race and slavery has complicated that sweeping assumption that they just didn't know, we now understand that this was a moment, or many moments, when the framers could have allowed women of property to vote. They could have allowed married women to retain property, could have modified divorce laws, or could have set aside the rule of coverture altogether and started from scratch. As with the issue of slavery, it turns out the silence around the status of women wasn't exactly a vacuum. When it came to examining the nature of women and their role in a republic based on equality, this was one of those uncomfortable silences, punctuated by odd outbursts, with all the tension that marks the difference between simply not seeing something and willfully ignoring it. So let's go back to the Adamses for an example of the uneasy silence. You may wonder how John Adams replied to Abigail's plea to remember the ladies, and he basically made light of his wife's request. He said, "As to your extraordinary code of laws, I cannot but laugh." Traditionally, one of the ways to dismiss female concerns has been to playfully impute power to them far beyond that of mere men. And sad to say, John Adams was guilty of that in his letter. In mock fear, he characterized women as, quote, "a tribe more numerous and powerful than other groups of disenfranchised people." They had special power. John Adams played his own variation on the old saw that the law gave women little power because nature gave them so much. Depend upon it, he teased, we know better than to repeal our masculine systems, although they are in full force in law. You know they are little more than theory. We men dare not exert our power in its full latitude. We are obliged to go fair and softly, and in practice, you know, we are the subjects. And what he's talking about and what makes women different from other disenfranchised groups is he's talking about the sexual power that women have over men, a power, unfortunately, with no power, as the law gave husbands total control over wives' sexuality. But in this little fantasy that John Adams is weaving, apparently women were so powerful that the only thing men could cling to, he said, was the name of masters. He even turned Abigail's concern about the physical and sexual abuse of women into a sly joke about how women whipped men into subjection with what he called the despotism of the petticoat. But as dismissive as he seemed to his wife in that 1776 letter, John Adams understood the deep contradictions in the theories that the colonists were used to launch a revolution. So remember, Abigail's writing this letter in the spring of 1776 as, we're heading toward the Declaration of Independence and really this official break from Great Britain. So really, just a month or two, a couple months after that, remember the Ladies' Exchange, on the eve of declaring independence, John started worrying about the core of the issues that Abigail had raised, and he did so in a letter not to her, but to James Sullivan, who was a formidable intellect in the Continental Congress. In his letter to Sullivan, John seesawed back and forth in a rhetorical dialogue as he tried to work out his thinking. So he has paragraphs like, in theory, the only moral foundation of government is the consent of the people. But to what extent shall we carry the principle? Shall we say that every individual of the community, old and young, male and female, as well as rich and poor, must consent expressly to every act of legislation? No, you will say, this is impossible. How then does the right arise in the majority to govern the minority against their will? Whence arises the right of men to govern women without their consent? Now, this letter is a very long, very complicated one, mostly because John Adams was struggling in this kind of back and forth way to form a coherent argument. At some points, he seems to be arguing with himself and losing. So he says, but why exclude women? You will say because their delicacy renders them unfit for practice and experience in the great business of life and the hardy enterprises of war, as well as the arduous care of state. Besides, their attention is so much engaged with the necessary nurture of their children that nature has made them fittest for domestic cares. That's the argument against women being politically involved. But he goes on to point out that that reasoning could apply to the general body of men who, quote, are wholly destitute of property, are also too little acquainted with public affairs to form a right judgment, and too dependent upon other men to have a will of their own. So if women are busy with childcare, men might have to have allegiance to, say, their employer. At this point in the letter, it seems John got a little too close to a line of logic that was a little bit too scary to follow to his conclusion, and he spends the rest of the letter focusing on the issue of whether white men of little or no property should vote. So somehow by the end of the letter, he could class propertyless men with women and children as fundamentally unfit for suffrage. In the end, in spite of his concerns, John Adams throws in the towel. Women cannot be given political equality because they just can't. It took a lot to befuddle the verbose John Adams, which should give testament to the thorniness of what they called the woman problem and the contested nature of the seeming silence. And here's another good example, I think, where they're having a conversation that you just can't believe they're having. So after the war, there was the problem of the loyalist properties. So on the face of it, the rules were simple. If a loyalist man left his home in the 13 colonies and fled to England, this property could be seized by the state as punishment for treason. And obviously, not only would the man and his family be deprived of the property, but so would his heirs. But what if, as in several prominent cases, the property in question was not the man's, but it came through his wife? That is, his wife's father had entailed land to pass through his daughter to her children, basically bypassing the husband. Yes, in the cases that came before the court, the wives had fled the country along with their husbands, but could that be interpreted as a political statement, a political action on par with a man's desertion? After all, lawyers for plaintiffs argued, a good wife obeyed her husband and followed him. Such a woman might have been a patriot at heart, but her political allegiance or affiliation mattered not, as women had little or no legal or political existence. Coverture. A woman's primary responsibility and allegiance was to her husband, not the state. That's the heart of coverture. So you see, heirs who wanted that property that would have come to them through their mothers were arguing that the wife's desertion didn't mean anything. Now, states, they want to keep the confiscated property, and they found themselves in the novel position of arguing that women could be citizens with a responsibility to the state that they were, in fact, capable of treason. In Martin versus Massachusetts, counsel for the state argued that when Anna Martin, the mother of the plaintiff James Martin, chose to accompany her husband back to England, that she acted in a political capacity, thus abandoning her Massachusetts property. Pretty interesting. Now, in the end, these cases were decided in a variety of ways. In the case of James Martin, he got his mother's property, which is undoubtedly what she would have wanted. But he was able to do so because the justices who decided his case proceeded from a very conservative point of view. They decided that married women were not autonomous actors apart from their husbands. But as I said, other cases went the other way. And moments like this demonstrate that the failure to ameliorate the degraded status of women was not inevitable, not unimaginable, that the men who were constructing a new nation could have also imagined new ideas of female citizenship. People will often ask me why I study women's history or why we should study, and I say it's because we learn things from women's lives, words, and work that we wouldn't know otherwise. Their sources provide us with new information, new historical questions and new topics, and new insights. For instance, asking the question, which I think we're at this point, why the founders left Coverture wholly intact as they crafted a new nation and new governing documents. I think asking that question offers a deep insight into their hearts and minds. So here is my theory about why the founders did nothing about coverture, not during the Constitutional Convention in the 1780s, and not at one of many times when the states were framing and reframing new bodies of laws throughout the late 18th and early 19th century. So here it is. During the constitutional era, this is the late 18th century, the framers were obsessed with an issue, one that was vital to the existence of the Republican experiment. Historian Joseph Ellis frames this as the viability of the nation. I call it legitimacy, but it's the same thing. In short, no one, former colonist or European observer, was certain that the Republican experiment would work if the United States, the Union would hold. It was precisely this uncertainty that led men such as James Madison and Alexander Hamilton to create the Constitution in order to consolidate and shore up power and union. This need for legitimacy to prove to themselves and to others that the United States was a real political enterprise gave rise to much anxiety and fear. And I think it is this anxiety of viability that prevented the framers from addressing the glaring contradiction of the category of citizenship in their shiny new machine of government. As I said before, they could have done many things to have brought women into the political fold, but they chose not to. I am postulating that this anxiety over legitimacy made the framers and founding men sensitive to anything that would seem to diminish or challenge their authority. In an age that equated masculinity with authority, that made anything that made them feel or seem less than men. Ceding the power over wives that coverture gave them would be such an act, not only for them in their hearts, but also in the eyes of the world. One could see this time in American history as a crisis of masculinity, with masculinity equaling authority and viability. The last thing the male revolutionaries would do would be to call their masculine authority into question by giving their wives freedom. I also would say that looking at this legal position of married white women deepens our understanding of the Constitution, especially in the issue which is very alive today about citizenship. I think it offers insights about how Americans get it, exercise, and lose it. And at this moment, as I'm mentioning the Constitution, you may be thinking, where are women mentioned in the Constitution? And well, you may ask, they are not actually mentioned. Interestingly, the language of the Constitution is surprisingly gender neutral. The framers used words like persons, inhabitants, and citizens, employing male pronouns to refer to only office holders. It's also true that women, along with children, were counted in apportioning quotas, but nevertheless, women are not part of the Constitution. And that omission, while perhaps not totally conscious, was in its way deliberate, resting upon assumptions about whether women could be in fact citizens or even on some level persons. And this partial presence of women in the Constitution, and I do use the language of being a ghost in the Constitution, a ghost in the machine, but it means that there's a very different idea of citizenship present in the founding document. For the most part, we understand the white male citizenship model. That's the obvious one. That's who the Constitution is about. As well, we understand the status of the stateless. The language about enslaved people in the Constitution reminds us what it means to be a person with no rights. But married white women present a third model, one that is more akin to slavery than citizenship, or if it is a kind of citizenship, it is one that is covered, partial, and contingent. Now, I promised a twist in the story, and let me lead up to it here. So I mentioned how, even though I was the professor of Coverture, taking this more in-depth look really affected my teaching. So as a historian of women's lives and gender, one of my bread and butter courses, one I had taught for years at that point, was the survey course in American women's history. And it's very similar to the regular US history survey courses you probably remember, like 15 weeks in a semester, covering the topic from 1600 to 1900, so dash through American history. Very similar. And in that course, I discussed coverture 3 times. The first mention of it was in week 2 when I talked about colonial women. That's when I introduced the definition. Week 4, that was when we would talk about Abigail Adams and the Remember the Ladies letter. Now, until 2012, my point about the Remember Ladies letter was not that Abigail Adams was asking for the vote. So people read that and they think she's asking for the vote. I would point out that this was ahistorical, that calling for women's suffrage in 1776 would have been seen as radical to the point of derangement. No, I pointed out, Abigail Adams was asking for something more measured, more modest, for the abolition or amendment of coverture. And in postulating the vote as the most radical political request Abigail could make, I was unconsciously reflecting a 19th century prejudice. Yes, by 1848, female suffrage was regarded as an extreme position by most Americans. It was So extreme that Elizabeth Cady Stanton almost didn't include it in the Declaration of Sentiments that was presented at the 1848 Seneca Falls Convention. But I was wrong. In 1776, it wasn't a crazy idea that white women with property could have been given the vote. In fact, in the first decade of the 1800s in New Jersey, women of property did vote until that right was taken away from them by the Jeffersonian Democrats. Abigail's request about coverture, on the other hand, was the most revolutionary suggestion she could make, that women could be whole persons, full citizens, and legal entities in the new government. That they could be given control over their own labor, over their own bodies, their own children. That is a radical suggestion. Okay, the third time I lectured about coverture came about halfway through the semester when I talked about in 1848 the passage of the Married Women's Property Acts in New York. And the Married Women's Property Acts really weren't about the rights of women, but by allowing married women in very particular cases to own property apart from their husbands, it was the first legal crack in the law of coverture. And that was it. That was the last time I mentioned coverture. And I couldn't believe that I was so incurious as not to wonder, what happened after that? What happened to coverture? And here comes the twist. We never got rid of it. Legally. And this is where I can't possibly judge the founders. They didn't abolish coverture, but neither did we. So what did Americans do? Well, we chipped at coverture over the last 300 years, but never getting rid of it completely. And knowing that explains several sort of puzzling phenomenon from the 20th century. So we get native-born American women who lose their citizenship when they marry foreigners as late as the 1950s. So you could be an American-born woman, your family been in the country since the Mayflower, but if you marry the wrong foreigner, you lose your citizenship. In many places, women were not permitted to serve on juries until the mid-20th century, thus encroaching on one of the most fundamental constitutional rights. Marital rape wasn't even recognized, let alone disavowed, until the 1970s. And this is all because coverture is still there. And the central idea of coverture was that all women were wives, and the effect of that rendered unmarried women null cases. So not too long ago, and I think I'm speaking about things that people in our audience remember, banks wouldn't lend money to single women. Not even as in the case I found when the woman in question had a job. She was actually seeking a mortgage from the bank where she was the bank loan officer. Even today, if a man tries to change his name to his wife's, or if you've brought property as a married woman, you've run into coverture. Most of the time, these vestiges of coverture are just annoying or even funny. But the question remains, why don't we just get rid of it? American law chipped away at coverture because, as it needed to, because there was a real reluctance simply to declare women to be equal under the law. And when I realized that, I started thinking about what would that look like, equal under the law? And of course, I went right back to slavery. And, we didn't pass laws against slavery because laws can be overturned, they can be changed, they can differ from state to state. To get rid of slavery, at least in theory, what was needed was a constitutional amendment. In fact, as I mentioned, 3 of them. So I started thinking about a constitutional amendment, and something about that seemed familiar. And then I remembered in the haze of my teenage years, when I really wasn't paying too much attention to what was happening in the world, there was this thing called the ERA. It was a constitutional amendment that declared women to be equal under the law. And so imagine my astonishment to go back and go, oh, the ERA, that's what we needed all along. As I wind up, remember that I began this research journey at that symposium about what would be the next big thing, what was going to be the most fruitful topic in research around the American Revolution. And you won't be surprised that I ended my presentation with the prediction that it would be women's history and especially coverture. And I hope this presentation has persuaded you as well. Thank you so much. And I'm turning it back over to Amelia.
Hi, Catherine. Thank you so much. That was incredible. I feel like it's just I learned so much. It's amazing. The way that, still, in the way that the American Revolution period, right, it can kind of feel like an intellectual exercise, but it's still something that's with us today and is still impacting us in 2020. So at this time, I'd like to open it up to questions. So in a box at the bottom of your screen. So if you want to go ahead and submit, we'll be happy to share those with Catherine.
And while we're waiting for questions, I want to share you my latest brush with Coverture.
Oh, absolutely.
So just a couple of days ago, we were doing something, my husband and I, that in Massachusetts was unheard of, but we were getting something notarized by Zoom, and you have to put up your ID and put up the paper and you sign it, and then you actually send it. So we're doing this, and he asked 2 questions. He asked both of us, gender neutral at this point, whether we were here of our own free will, which is odd, right? It's an odd question. And then asked if there was anyone else in the room with us. And these are all vestiges of coverture, because it used to be that the law worried about a woman having no power, legal power, and being made by her husband to sign over anything like that her father gave to her. So let's say the father gave the woman or willed her a field, and the idea was that she was supposed to keep that field. And the husband pressured her basically to give it to him. And so what they're asking is, and what they used to do is they used to take the woman into a room and say, are you doing this of your free will? He's not like threatening to beat you or something like that. Now, because we're modern, we don't talk about women in that way. So they had to make it gender neutral. But it was this funny moment where my husband and I are sitting there and they're saying, is there anyone else in the room with you? And I just thought, it's Coverture.
That's kind of amazing. So I have a question, and I guess this is maybe, I don't know, hopefully within your purview. So it's interesting that you're talking about how women couldn't hold property and that it would pass through from the father, to her children. But so this kind of like brings up in my mind Martha Washington, right? So we hear about how George freed his enslaved people when he died, but the women or the people that were held in bondage by Martha were not freed. So how does that fit into what you're saying where women couldn't own property?
Yeah, actually, when George Washington married Martha, her slaves became his. I'm not so familiar with the Washingtons, so I'm going to be really careful about this. I think they might have entailed slaves too, so that he could not legally free them because they were going to pass to Martha's children.
Oh, so maybe that does
Yeah,
make sense.
it does
Yeah.
make sense. I have to tell you, explaining entailment has become so much easier after Downton Abbey. People understand the idea of passing through. Yeah.
Yeah. No, I guess that does make sense. That would be why. So one of the concepts you kind of mentioned, but just in passing, was that of femme sole. And so I was wondering if you could maybe tell us a little bit more about that.
So what's interesting is, so there's this legal exception that you could get this exception that you could open up your business. So we weren't even thinking about Coverture. In the 1970s, we were looking at women's history. We were looking for women who had careers or jobs, right? And the easiest thing to do was look for how many women in a town had applied for this thing. And actually, it was pretty rare, and we kept looking around, and it just didn't seem to make sense that it was so rare, because we did actually know women who were printers, who ran taverns, who had stores, And what it turned out to be is that this is where everyday life takes over. Women just didn't bother. So very, very few women took the steps to actually get legally sanctioned. Most women and their families just didn't bother. I mean, if you're living in a small town and you're got a store, technically you can't make a contract, but if you don't pay your supplier as a woman, they're not going to come back. So it was more that it was kind of policed by the community. And once we understood that the formal exception didn't mean that they weren't doing it, then we discover lots and lots of women doing lots and lots of things.
Great, thank you. We've had a question come in, and they're asking how much of Coverture was carried over from British rule.
So at some point in the colonial system, we had 3 forms of coverture. The British, because those were British, we were British, they're British colonists, I'll say we, the people that were British colonists. There was a Spanish form of coverture that came from Spain, and that was located in mostly the Southwest. And then there was a French one. And everybody who remembers Streetcar Named Desire and Stanley Kowalski talking about the Napoleonic Code and whether that property, Belle Rive, belonged to him as well, that's what's there. And in fact, Louisiana, because they're an exception to a lot of things, still has vestiges of that coverture. But because the British, the British form of coverture just became the default, the wall. And it was wholesale. So I should have probably contextualized this a little bit more. Coverture had been a practice in place for centuries. So when Abigail Adams is saying that thing about the ancient rule, she means it's been for centuries. But it was very lightly codified. It was in black letter law. Koch wrote about it, but it was like a couple lines. It was something like the husband and wife are one, and that one is a husband. What happens in the 18th century is I want to say Blackwell. Am I saying right? Great legal theorist, whose name is possibly Blackwell. I may have to space that. He began really codifying law. He wanted to really put law, take equity practices, streamline things, codify things, and he actually built on this. So coverture gets reinvented, oddly enough, right before the Revolutionary era. So in the in the 1740s, 50s, 60s, when men of the Enlightenment are talking about freedom and individual liberties, Blackwell is actually buttoning this stuff down. So it was both ancient and it was also enlarged upon in modern. And really, it just got lifted right from British law and went plunked right into the American system. And if there's a lawyer out there, please correct me if I mean Blackwell.
So we have a new question. So could you comment a bit more about the significance of some of the equitable, statutory, and common law exceptions to coverture? For example, in Pennsylvania, there was an 18th century statute permitting married women under certain circumstances to conduct business as femmes sole.
Yeah, I think we talked a little bit about that. Everybody had that. It was in Pennsylvania, but everybody, because it came from British law, there was always an exception for that. So you could legally do it. There had to be a man somewhere there to sort of guarantee it. But what's most interesting is not that that exception existed. I think what's most interesting is not that that exception existed, but that it was, honored in the breach. That when it came to just everyday life, everyday practice kind of took over. So men and women are running businesses side by side together. There's also the deputy husband, which meant that if a man was out at sea or traveling in some ways, an itinerant preacher, that a woman could make contracts on his behalf, to buy goods or to buy goods for the store, to sell, or whatever you needed for business. So there is that exception, as you point out. But I think what's so much more interesting is how the kind of it's almost like the power of the everyday took over.
Yeah, that's
and let me just add this. One of the, I talked about how we chipped away at coverture. The other thing is coverture is very ungainly. It may look elegant to say women have no legal existence in there, but we actually, as a country, we needed women to do stuff. And as we needed more women to do stuff, we would make it okay, that we could hold jobs and get paid and be held to account and testify in crimes. Like when we needed women to step up, we had to remove some of coverture, but it was definitely in an as needed capacity.
Yeah, and I think that's really interesting, especially on Nantucket, because that's, a maritime community where many husbands were at sea. And so there were women on the island. So not just in Pennsylvania, as the question asker, gave as an example, but that, there were women conducting business on the island as well.
Let me put you on the spot, Amelia, for a second.
Please.
What would you say is the ratio or between women doing things, running businesses, making contracts, selling, vending, pouring, and women who applied for the femmes sole exception?
Well, and I think it changed over time. So I definitely am not trying to give out statistics here on the fly, but it definitely changed over time. So as, when we actually had a really great presentation over the summer from Michael Harrison, who did some research into Petticoat Row, which, if you're not familiar, was a street on the island that had a large number of women-run businesses. And so there's a common misconception that while the husbands were at sea, that that this was a flourishing, center of commerce run by women, hence Petticoat Row. But it turned out that it was actually more after the end of whaling on the island, and that as men, were kind of leaving for the gold rush, and they were older men on the island or younger, children, that the women did businesses then. So I think it's like an area for more research, to be sure, just to kind of separate that myth from what actually happened. So that's why I think this is such a timely conversation for us.
And may I also thank Mary Heen for Blackstone. Blackstone is, thank you, Mary, I appreciate it. I knew I made a mistake when I realized that the books behind me are Blackwell Companions.
So we had another question. What other countries, if any, still maintain the law of male-dominated society?
I think that, many is all I could say. And I think what's interesting is not the extreme ones that you would imagine, where women can't drive and they don't exist as people, and, they have to always have accompanied by male, but how it kind of crops up in what we would consider more first world places. So there's somebody who is just mentioning a comment that in 1971, I was only allowed to have a credit card if my husband signed on too. I was fully employed in age 21. And that's exactly, I collect these stories of coverture. I mean, 1971 was not that far away. And it's easy to just say, oh, it's sexism. It's just men dominating women. But I think there's it's important to see this as coverture, and that it can be, we can't outlaw sexism, but we can outlaw other things. And law matters. I do actually believe law matters. And so if coverture had gone, that would not have happened, right? Now, you could still get sexually harassed because there wasn't sexual harassment laws in 1971. But if we got rid of coverture, so many things like this would kind of disappear. And as I said, some of it is funny, like the one we just had that I related. Some of it's funny, but some of it's serious, especially if you file your taxes as a married couple with your name, separate names. There's a case in California that took years for a husband to switch his name to his wife for no reason except that it was, not the thing. So I'm more interested in sort of how these things kind of crop up, and that we recognize it a little bit like, I don't know if we have, I'm sure we have a lot of gardeners in the audience. So there's something called bindweed. And bindweed basically grows under the ground, and then it'll pop up in your garden, right? And then it'll grow under the ground and pop up in someone else's garden. And that's a little bit coverture. As you're a woman and you're negotiating through the world, something will pop up, and it will be because coverture is in place. And it might be employment discrimination, discriminations of all kinds.
Thank you. Yeah. So what would you say is the status of the ERA today?
Yeah, so once I discovered the ERA, like, rediscovered it the way Columbus discovered America, I kind of went and looked, and there is still a movement to pass the ERA. And, and I read the websites, and, terrific stuff. There's always a limitation to constitutional merit, a temporal limitation. I think it stopped at 3. And then they extended, and then that deadline passed. And now they're trying to resurrect. They basically want to revitalize the movement, extend the deadline. And I think Virginia, so we're just down by 2. So there is definitely movement. And it's still, the patient is still alive. There's something else I wanted to say about it. And and what I was, of course, most interested in was not all the good, support for ERA, but what was the argument against it? Because it seems on some level like, why do we need it? Well, if we don't need it, let's just pass it anyway. Oh, no, right? Suddenly people get very exercised at the thought of passing this. And so there's obviously still a lot of juice around this idea. And the only really argument against it was, we have all these laws. And this is just not a strong argument, because laws change all the time, and, you know, laws change all the time. This is why you have to enshrine it in the Constitution. So I think it's still alive. And if anybody out there knows more than I do about that, please let me know.
So we have time for just a few more questions. So one that's come up is, do we see coverture holding out more prominently in states that held longer to slavery? And could you just elaborate a bit more on Louisiana, which I believe you mentioned earlier?
Yeah, Louisiana coverture is interesting, and I'm not going to expound on, because there's something. Louisiana, which is of course a form of French coverture, has been argued by scholars both ways. It's, in some ways, it's been argued as more restrictive than British coverture, and in others, it's been argued as giving women inadvertently more freedom. And I don't know enough about both of those arguments to really be able to navigate my way in there. So that is something, if I continued along this path, I should really know a lot more about Louisiana coverture. And I would definitely say that one of that was such a smart remark, one of the traits of slave societies. So there's a difference between societies with slaves and slave societies. And we've always characterized the North as a society with slaves and the South as slave societies. When you consider that all of America's financial infrastructure was undergirded by slavery, we may have to pass on that a little bit. But it is true that real slave societies have much more stringent gender restrictions, both ways. Women definitely second class there, but standards of masculinity and femininity are much more hardwired and much more stringent, because the tension in slave societies is about keeping this other group of people oppressed and working, right? And you do that through physical force and fear. And that's, and the world has to be much more rigid and ordered. So, you know, if you were a woman who wanted to, you know, have a job, of course that's not going to happen. But if you were a man, the first son of a family, and you had no interest in, you know, running a plantation, or didn't want to oversee that, tough, you had to do that. So coverture issues, and I'm sure it's not surprising, do linger on much more. So an example would be women on juries. So women started serving on juries in the 1940s and 50s in the North and the West rather than the South. So definitely the South is much more conservative.
So I think the last question that I'm seeing here are, were there instances where a husband was prevented from allowing his wife to run his business or inherit his property that you're aware of?
Yeah, so the property, I mean, if he didn't want a wife to run his business, it just wouldn't happen. That just, he just wouldn't permit it to happen. A femme sole had to be agreed to by him. So there's no way that she could do it without him. Inheriting property is kind of interesting. And I do want to say that widows and single women had their property protected by law, but it was always seen as an exception, right? Because coverture presumes all women are wives. But what you don't want in a society, in a town, you don't want a man to die and then the woman has nothing, right? Because now she's on the public charge. So there was something called widow's thirds. So the idea was basically, if a man died and his property was to go to the eldest son or to somebody else, she would get a third, her dower, they called it. And it would be some combination of material things like her own clothes, pots and pans, maybe some land, maybe the house, you know, it would be enough to keep body and soul together. And it was not out of any sense of fairness. It was purely practical, because they recognized that if the guy dies and gives everything away, she has nothing and she's in dire poverty. Now, some men were kind of mean, and they would actually try to deny the widow's thirds. And that's when the equity courts would come in and be equitable and basically counteract that.
Well, this has been fascinating, and I've certainly learned a lot this evening. And I just want to say thank you so much for taking the time to talk to us tonight and to share this.
Oh, it was my pleasure, and I think this is a wonderful series, and I'm glancing at some of the questions, and I'm so happy to bring this to such a well-educated and engaged audience. Thank you all.
And that's so true. So thank you again to our members for coming tonight. And we wouldn't be able to do programs like these without our members. So if you have not joined, please consider joining by going to nha.org/membership. Thank you.